other than not entering into a relationship in the first place, there's really one primary way of avoiding that problem, and it's to consider entering into a financial agreement. The Family Law Act permits couples, be they heterosexual couples or couples in same-sex relationships, to enter into financial agreements either before they commence a de facto relationship or during their de facto relationship. Those financial agreements are sometimes used as a settlement document after a relationship has broken down. But the essential, if you like, prenups, as they're known in a marriage context, apply in de facto cases, and they can be used to enable parties to set down in writing what they agree should happen to their assets and their income in the event their relationships break down. They can also provide for some of the property or all of the property to be dealt with. It's not necessary to have a boots and braces approach to these things. It's also possible for parties to make provisions in those agreements to ensure that their estate management issues are tied in with their succession planning and will-making issues, so that it's often seen as a sensible thing to do in combination with estate and succession planning matters. But each of the parties to the relationship will require their own lawyer, and those lawyers have to give statements of independent legal advice as part of those agreements to make them legally effective. But they are becoming increasingly common and provide a lot of certainty to people where there otherwise may be no certainty.